Okay, team recording. Yeah, we're up. Okay, so this pops up on the screen. Going to see. This is all about broad ultra-vires, and so this is kind of contrasted with the two previous weeks. This is the third of 3 weeks where I'm going to talk about the grounds for judicial review. And this part, it's kind of something of a catch-all. It's really all of the other ways in which you can seek some sort of remedy, one of those writs, from an administrative decision maker. And if there's just one takeaway from this, it is much harder to get these than it is to get, essentially to succeed, than it is to succeed with breaches of natural justice and breaches involving narrow ultra-vires. And there's a really important reason for that. And that is that the broad factors, the variety of things, unreasonableness, uncertainty, and so on, the key takeaway is that the courts are reluctant to jump into the shoes of the decision makers themselves. And I'm just going to explain that the whole purpose of judicial review is that the courts aren't looking at the quality of decision makers. It's not really what they're about. We have an entire separate system that is set up to look at the quality of an administrative decision maker. It's called merits review. And that's usually done through the tribunal system, where the decision maker steps into the shoes of the tribunal steps into the shoes of the original decision maker in order to weigh all the evidence up again and remake the decision. That's merits review. And we've got to be really clear here that the courts don't do merits review. Tribunals do. Tribunals are an extension of essentially the executive arm of government. And they have the ability to take evidence and do what people do in the tribunal environments, throw things at each other, whatever they do, in order to remake the decision. Here, we're still looking at judicial review. And judicial review is done by the courts. They are looking at the lawfulness of the decision. And so, look, when you're looking at the lawfulness in terms of the natural justice aspect, or looking at the lawfulness in the case of the narrow ultra-vires stuff, where they've just straight up departed from what the statute says that they had power to do, the courts are happy to go through and do that. It's a pretty low bar. Oh, look, here's a statute. It's about the marketing of eggs. Oh, look, you're doing things involving the destroying eggs for safety reasons. That's outside the scope of those powers. That's Shanahan. That's straightforward. The courts can jump in and they can do that and they can look at that. What they don't want to be doing is stepping into the shoes of the decision maker. And that's why the bar to obtaining one of these remedies under these areas it's higher. It just is. And so I'm going to go through this. It probably isn't going to be a long lecture, but just make note that these considerations, these sort of the grounds that the courts go through and can go through, and you can seek judicial review under, often they are done concurrently. So if you want to get a particular result, you go with the one you're more likely to succeed in, which is the narrow ones, natural justice, as well as the with things that have just gone outside the scope of the power. These are often argued at the same time, but they do that as sort of a last chance salon. They're harder to achieve, they're harder to obtain as a result. Okay, and the areas that we're looking at here is this idea of taking things into account that are relevant. Where a decision maker is taken into things into account that were irrelevant as part of the decision, yeah, sure, we can go and seek a remedy and results of that. And the reverse is true. If they're taking something irrelevant into account, we can seek to obtain a remedy for that as well. But we have to be careful because it's starting to delve into looking at the quality of that particular decision and that particular piece of evidence. And certainly unreasonableness as well. That's that idea of the decision that's so manifestly unreasonable that no reasonable decision maker could make. That's a pretty high bar, rocking up to the court and arguing that particular point. Where decisions have been made where there is some evidence, but there's not enough you're trying to prove as a point of law. The decision maker could not have made that decision based on that evidence. Again, hard to go through and prove. Uncertainty is actually pretty narrow. It only applies in circumstances where the instrument giving the power is written and expressed in an unclear way. The bad faith, by the way, which is the last one, is also hard to prove because, again, you've got to prove that people are doing things for whatever, a purpose that doesn't flow from the statute. But number 5 in that list is, I think, was one of the more interesting ones, where a decision maker hasn't used their discretion. And the reason why I find this the most interesting is because you guys are probably aware you're having to deal with policies and the interaction between decision makers, particularly government departments and universities, that have policies that people follow blindly. That can be an error of law, and that can be subject to judicial review. Okay. Now, so again, just note, when we're going through these things, you'll get the sense that the courts, unlike natural justice and procedural fairness and the narrow Vires, where they're quite ready to jump and give people a remedy when decision makers have stepped outside the scope of their power or they haven't followed these inherent rules for natural justice and procedural fairness. They're quite happy to jump in and do that. You'll notice a trend amongst this stuff that sort of presumption, that theme, doesn't apply. In fact, it's the opposite. The courts don't jump into this stuff readily. There's this great deal of reluctance, reticence in terms of doing that. And so, I love it. Is that Justice Mason? Oh, it was Chief Justice Mason as he was by that stage. Was my favourite High Court judge. Still alive, actually. He's like 97 or something. Sir Anthony Mason. I love that first line. A want of logic is not synonymous with an error of law. Decision makers can be bad at their job. They can be bad at their job, and that is not going to render the decision inherently reviewable in the courts. Decision makers, and we think about this. We think about those who've ever had to deal with government agencies, such as Centrelink, or the Department of Veterans Affairs, or the Child Services Agency, or James Cook University, that you are going to run up against people who are going to be weighing up bits of evidence to come to a particular result. And sometimes things to you are going to look illogical, sometimes they're going to look unreasonable, but you appreciate that the bar to get the courts to step into those decisions is actually pretty high. Don't get me wrong, you do have mechanisms to have those sorts of decisions that you think, where they've weighed the evidence up wrong, are somehow invalid or unjust. But the proper place for that is in the merits review system, which we'll go through in a couple of weeks' time. All right. So we'll start with the first of these, which is not taking into account relevant things and taking into account irrelevant things. Who here is doing evidence law at the moment? Yeah, couple of three doing evidence law. Now, what is the two-step process you use in evidence law to determine whether or not you can adduce a piece of evidence? First thing, it must be relevant. If it's not relevant, it can never be adduced as evidence to prove a particular point that needs proving in a court of law. That's the first step you do. Second step is admissibility. Do a whole bunch of other rules in relation to that. But there's no point checking admissibility if things aren't relevant. In order to prove something in law, in our legal system, you rock up and you bring some evidence, and that evidence has to connect to, and to be able to prove the particular point that you're doing. It has to relate to it. If it doesn't, you can't adduce it. You can't put that before the arbiter of fact, which for administrative decisions is always a judge. Can't think of any situation you'd ever use a jury for these things. Couldn't think of any situation where that would come up. But we are aware in other spheres, for example, in defamation and in the criminal law, where you do have a jury, information that is irrelevant can't be put to that jury, and the jury gets instructed to disregard it. And in some situations, if it's highly prejudicial to the accused, the entire jury can be dismissed and a mistrial ordered. And judges get really grumpy with barristers that try and do things like that. And if you do it often enough and or deliberately enough, you get hauled before the Bar Association or or if you're solicitor, before the Legal Services Commission. That's the body. Did they really?
Yeah.
Wow.
They got that
Oh wow.
alleged evidence that he was
Molesting.
gay
Yeah.
and not necessarily molesting, but just having sex with men, because at the time, being gay was bad.
Yeah.
And then it was obviously deemed inadmissible because it was completely irrelevant. But they knew it was going to be irrelevant.
Oh yeah.
Yeah. To get the media attention.
Absolutely, and that's why in the criminal sphere, there is a tendency for the accused, if it's going to be the sort of crime where the general public's already found you guilty, you've been accused of something, child sex offences, or of killing somebody in horrible circumstances, you're already guilty by association, and a trial that involves 12 of your peers are going to walk in thinking you're guilty. A bit like when I did legal studies at high school, and I had to be the defence person, and the jurors, who were my fellow classmates, 12 of them walked in chanting, "Guilty, guilty," as they're walking in, and it's like that. Yeah, we weren't going to win that one. But this idea of prejudice is really important. When information is put, again, we're thinking here in terms of the criminal sphere, in terms of it being prejudicial, but also in terms of administrative decision-making. Information can come before an administrative decision-maker that can be absolutely and utterly damning of the character, likability, and other features of the person whose rights are being determined by that decision-maker. But if that stuff doesn't actually relate to the decision that's being made, that is an error of law. Now, in evidence law, we would go and seek for that evidence to be struck out, not put to the jury. But here, the avenue of attack is a little bit different. We are going through and looking at what the administrative decision maker's done in terms of how they've weighted things. And as we're aware, the Acts Interpretation Act, as well as most of the statutory frameworks say, when you make a decision, you're a government department, you've got to give a statement of reasons. Doesn't apply in the common law, but does under the stat frameworks. And so going through those reasons and looking at those pieces of evidence, those are the things we can go through and point to these and say, that doesn't relate. Me having a criminal record doesn't relate. Hypothetically having a criminal record may not relate to a decision to deny me a blue card, for example. Sure, if that criminal record was for a string of horrible child-related offences, that might be probative, that might tend towards it. But a criminal record for fraud, or a criminal record for bashing someone in the head when I was 19, that sort of stuff is irrelevant. And if that comes up in the record of things, that is the sort of area where you can use the courts to step in and seek a writ as a result. So just make note that with these things, the key thing, or key word, is must. It's a magic word. When you're looking at these things, some things just by the way the instrument is structured, have to be taken into account. And the instrument will say, when you are determining whether or not to refuse someone a passport, you must consider these list of things: the likelihood that they're going to commit crimes overseas, the likelihood that Australia's reputation is going to be infringed, the likelihood that all of these factors listed in the statute, and the decision maker has to address them. If they don't address them, we can seek a remedy. And again, we're aware with the way remedies work, there's a little hierarchy of them. Ideally, and for those that have done presentations, I've talked about this recently, in most situations, when a person's declined something like a permit or a grant or some other benefit that they're going to have, the best remedy we want is a writ of certiorari. You said no, we want the court to change that to yes. All right, that's great. That's the best remedy we get, but in the alternative, if there's an error of law, we'll remit it back to the decision maker and they'll have to remake that decision, sure. Or we can get a declaration of the rights of the parties in relation to that it can go back, but this is the way this particular framework operates. The government department can either choose to follow that or not follow it. Generally, they do follow it in terms of declarations. So we have this little hierarchy of things that we want. Much like when you're taking other causes of action. So if you're the Crown prosecutors, you want to get them on this crime, but if you don't, you'll get them on this lesser crime instead. Or you're suing somebody in tort, for example. We want to try and get them on battery, but if we can't, we'll get them in negligence instead. Harder to prove, and we've got contributory negligence aspects. That's how those things work. You guys should be in the habit of thinking about the best remedy and then the alternate remedies that we want under that, if we don't get that main one. Okay, so when decision makers are looking at the quality of evidence, they're looking and examining a particular piece of evidence, the quality of that evidence in terms of the relative weight that's placed on it, that is going to be a finding of fact. They're going to have a bunch of things that have come up. And again, I'll think of a passport. So I don't know if you're aware of this. Those that are Australian citizens, by default, the Passports Act says, if you want a passport, you get a passport. That's the default. By default, you're allowed to get a passport. Right? The minister has the onus, and in situations where they want to decline you a passport, going through and jumping through a bunch of hoops. And they have a bunch of things they've got to take into account. And as part of going and doing that, they're going to grab a whole bunch of evidence, and they're going to weigh those things together to determine whether or not they are going to grant you a passport or not grant you a passport. Now, when doing that, the amount of weight when looking at a particular piece of evidence that is placed upon it is important. And when issuing decisions, going through the statement of reasons, usually the decision maker will say how much weight they've placed on each of those things. And that aspect of looking at the quality of each piece of evidence, all right, in terms of its probative value, the amount of value we're placing on this, that's an issue of fact. What do we know about issues of fact? We can't appeal that stuff. And in the context of judicial review, we can't use the JRA or the ADJR in order to seek for that quality to be changed by the decision maker. It's fundamentally not what this is about. Merits review can, when we send it back to the AAT or QCAT, put it in front of decision maker who's going to step into the shoes of the original decision maker, that's fine. But we here, when we look at judicial review, don't look at the internal quality of that, the issues of fact. What we do care about is this idea of relevance and irrelevance under this particular area of broad ultra vires. Okay. Now, sometimes these decisions that are looking at the the various facts and determining what the weight is. Sometimes that's done by bureaucrats and government departments. Sometimes it's done in incorporated associations and following the various rules and determining whether you can expel a member or not. Sometimes, though, it's done by the minister herself or himself. And we do have to appreciate, and going back to those ideas of standing that we've had earlier in this subject, that ministers make political decisions. Decisions inside cabinet, behind closed doors, those are political decisions. The courts don't get in the way there. And the courts do say that, look, when decisions have been made personally by the minister, when determining what the various weight to place on these things, some of those decisions are inherently political. We will place a lot of weight on the fact that this particular child molester has a particular history of going overseas and doing things. We can place a great deal of weight on that. But we can only do that in situations where that is a consideration that is relevant. So you've just got to appreciate that's almost this two-step process. We can look at the weight. Well, the courts can't really look at the weight that's inside it, and they do have to take into account the fact that if things are done personally by the minister's making decisions in terms of weighting stuff, that's political. It's a political decision. Still has to follow the statute, but that's political in nature. And just because there's outrage doesn't change the way things are relevant or irrelevant for the purposes of administrative decision making. The mere fact that a decision may cause public outrage in terms of how it is not, strictly speaking, a relevant consideration. Look, it can be. In what situation? When can the public interest be taken into account as a relevant consideration? When the statute says so. So things like environmental planning things. Clearly, when making a decision under that legislation, they do look at the public interest as part of the decision-making process, because that's what Parliament said. When making a decision in regards to passports, it doesn't. The public outrage in relation to that isn't a relevant consideration, because that's what the statute says. Okay. And in this Hindi case, they use this phrase that when considering stuff, there is this idea that when people are looking at the particular qualities of a piece of evidence, they have to give it, and I use my best Kevin Rudd impression, which is a fair shake of the sauce bottle. I probably said that not at all like Kevin Rudd would say it, but they actually have to go, and when they're considering these things, they actually go and look at it and actually examine it. These things, again, sometimes these things have got evidential problems, because if a government department says, I went through and looked at that, okay, how am I going to prove otherwise? I got my FOI request and it says that the person looked at it. We can't look inside their head. We've only got the evidence that's available to us in order to determine that. What you find, things like this come up though, when for whatever reason bureaucrats have written down somewhere else, I know I didn't really spend much time on that at all, or something along this. And when some aspect of evidence comes back, then you can go back and seek some review in relation to that. All right. And we've got JR and MR. What's MR? Merits review. Look, I make the point in this subject about it being this curve, this hill. Once you're up a certain point in the hill and you realise you're going to get over it, and everything after that ends up being easier. This is a really key concept And if you do appreciate and understand this distinction between the roles of merits review and why it's different and distinct from judicial review, that is a massive part of this subject, just understanding this distinction between them. Merits review is stepping into the shoes of the original decision maker, remaking the decision by looking at the evidence itself, re-weighting things, re-examining things. Judicial review is looking at the decision that's been made to see whether they've followed the statute, either the narrow stuff, which is easy, like you exceeded your powers, that's fine, didn't follow natural justice, that's fine, get a remedy. But these things are a little bit harder. When we're looking at this, this taking of things into account either way, this can be trickier to prove. Now, if a statute says the minister must take into account this, this, and this, and it's clear on the record that they haven't, well, you're right, you can score a win. But often it's not. Often it's much subtler than that, where they'll say that they've taken something into account, but you actually read the internal logic of it, and it doesn't seem that the internal logic actually flows from that decision that's been made. And just trying to give an example. So the relevant and irrelevant in regards to passports. So say you've got some person that's a child molester of some sort applying for a passport. It's difficult for us to step into the mind of the decision maker to see how much weight they put in that. Now clearly, child molesters, we don't want them getting anything. But stepping into the mind of the decision maker when denying them a passport is tricky. It's a tricky thing to go and do, because the Act will list relevant considerations, and they'll be usually stated in broad terms. The minister must take into account the likelihood of this person committing a crime elsewhere. That aspect of likelihood, that's a very qualitative decision. You have to look at that particular person, look at their record, and make essentially a value judgment. Well, if they committed, again, this sounds awful, I've got to be careful when I phrase things like this, particularly live streamed on YouTube, that not all child offences are the same. For example, if you were criminally charged when you are, say, 17 years old with having sex with a 15-year-old, that is a child sex offence. Police don't usually prosecute, but they can. They can do that because there's a sliding scale. I went and had to sue when I was doing a placement with the DPP, and we were bringing action against a 20-year-old that had sex with a 14-year-old. That seems a little bit gross. Yes, it is in fact gross. That's a child sex offence. That person's on the register. Now, but in 25 years' time, assuming that person does nothing else bad for society, if they got declined a passport because one of the considerations the minister must take into account is previous criminal history. And so the weight is the key part here. And unfortunately, that is difficult to get in terms of judicial review. Merits review, fine. Not judicial review. It's hard. Hard to go through and do. And so just make note, courts don't like stepping on the toes of the tribunals. It sounds a little bit unintuitive, but really they know that their roles are distinct and different. The process needs to be separate. Okay, and so look, to be frank, this is the sort of thing that will appear in your exam. That idea of when going through these things, and you'll have access to previous year exams, when you'll be looking at particular scenarios and the minister's doing things, one of the things they invariably do in these exams is have a piece of information and take that into account with their reasoning. And you guys, again, particularly those that have studied evidence, you should be able to see the connection between those two things. This is an exercise in logic for you guys. This piece of information was taken into account. Actually, it was irrelevant in terms of this particular decision that's being made. Something I sort of challenge you guys at this stage to go through and start thinking about that idea of relevance. Okay. The Wensbury principle. This is the next area. So now, relevant and irrelevant considerations. Yeah, that's a reasonably, moderately high bar. Unreasonableness has a really high bar. It's really hard to prove. So Wensbury's case involved a decision, I think it was around the war. Yeah, I think it might have been during the war. And the decision was involving movie theatres. Might have just been one theatre. They weren't, children under the age of 15 weren't allowed in the theatre on their own. And so they, for whatever reason, somebody sought review of this. I think it was one of the Veterans Associations, actually. Picture Houses, Wensbury Corporation. Yeah. Took umbrage at this and went to seek review. Seems like a minor issue to seek review over, but nonetheless, this case ended up going to the House of Lords, and we still to this day refer to this as the Wensbury Principle. And it goes like this: something can be struck out as being grounds for judicial review, so this is one of the grounds, if the decision is so unreasonable that no reasonable decision maker could have ever come to that conclusion. And I'll say that again. You can get up, you can succeed on this ground of judicial review if the decision that was made is so unreasonable that no reasonable decision maker could have ever reached that conclusion. Then you can seek a remedy in judicial review. That is a very high bar. Unreasonableness is difficult to prove because it turns out decision makers can be rubbish at their job. And that is not grounds for seeking review under this area. It's fundamentally grounded in logic. If the decision is so illogical that you just can't see a connection between things, that's when you can get up in this area. So going back to my passports example, taking into account criminal history, that involved like fishing accidentally on the Great Barrier Reef. Strict liability offence, you're in the wrong spot. You get a fine. All right? Things where this is essentially a strict liability offence, taking that into account when determining whether a person ought not to get a passport. There's just no logical connection between those things. But it is a high bar. So, for example, that having 15-year-olds not being able to go into the movies without an adult on a Sunday, that was held to not be unreasonable. So, strictly speaking, Wensbury is actually obiter dicta, but it's where the principle comes from. That's just what we call it. It's the Wensbury principle. In that Shetu's case, they use that phrase. It's where you can't determine or you can't see what the internal logic of a particular decision is. That is where things can be considered to be unreasonable. That is the highest of bars. And again, the courts here, this is Justice Spiegelman, said that, look, we have to be super careful, really, really careful in regards to this. When we're looking at the reasonableness of a decision, we have to be careful that we are not jumping into the sphere of merits review. We have to be super careful that we're not standing on the toes of the tribunals and their ability to go and rehear decisions and step into the shoes of decision makers. It's a fundamental thing. Think about the boundary between those two things. The courts don't want to blur that boundary. And as such, unreasonableness is hard. And they, as a result, try to characterize it in terms of this illogical series of steps. That's the mechanism that you can use unreasonableness. We're not looking at the quality. We can't look and actually look in terms of the weight. We can look at the holistic when you've placed weight on all of these things and come to this particular result that doesn't flow from that. But we can't look at the inherent factual analysis that the decision maker has made in regards to those little pieces of evidence. Okay, now it comes in 3 flavors. Irrationality, which is essentially the following of a path that somebody else would come along and couldn't come to the same conclusion, or rather, as an issue of law, if when you've stated all of your reasons, the judge goes through and just cannot see how you've joined these dots together. That's this internal logic. But there's sort of 2 other branches of this. Now, in constitutional law, which some of you guys are doing, I imagine, they talk about tests of proportionality. Proportionality is it's a tricky concept. It's that idea of where an amount of stuff, usually here we're thinking in terms of dollars, needs to be spent or poured into a particular area, that amount of stuff or time or effort, or in our case weight of decision making, needs to actually align with the particular purpose or thing that is trying to be achieved. I talk about proportionality is the amount of weight you have that you're taking into account at the start of a decision in relation to the end result. I don't really know how to explain that very well. I'll get to that in a minute. And the third one's discrimination. I'll start with irrationality though. The fisheries case. One of the ways that this can come about is, and I do love this phrase, when sitting there, I think it was trust law actually, when I sat this as a student, and I remember Thomas Middleton saying, one of the reasons for setting up trust up is that you can do income splitting. He writes 180,000 on the board and divide by 2. You just see this look of horror around the room. There's a look of horror when numbers are being drawn on the board and there's like a division, and all the law students in this room have this look of like, whoa, we didn't sign up for this. And I've taught tax a few times, and similar things apply when you're in a room with the accounting students and the law students. These guys love the law stuff, the stories. These guys hate the stories. They love the numbers. And I often say during that class, when we come to some of these decisions, judges are not good with numbers. They don't like them. They don't like them. They do some funny calculations. But the key thing to note here is in terms of administrative decision-making stuff is that when administrative decision makers are blindly going through and looking at numbers without thinking about them, without actually having any understanding of what the heck that they're looking at, that's going to be an error of law. You have to actually know a little bit about numbers. Sorry, law students. Dust off those year 10 calculus books or whatever you guys do in Australia. Because if you have data, you are making administrative decision making. Essentially, you're taking data and you're making an administrative decision making. You have to understand what the data is. You can't just blindly throw some bell curves at the person you're making a decision for and spit out a result. You have to be able to demonstrate that. You have to demonstrate the internal logic in regards to the data itself. This is the idea when we're talking about unreasonableness, it's got to be logical. And so that aspect of it that idea of blindly flowing data. And look, to be honest, there's a lot of bureaucrats who are not good with numbers either. And they're throwing things at you. I had to smile sweetly when I looked at the graph. You have your Centrelink, you have the robo-debt. Robo-debt. Have you guys know what I'm talking about here? With those letters, they were automatically generated letters that were sent out to people for outstanding Centrelink debts. They just did some statistical analysis and worked out a whole bunch of people, so had Centrelink stuff outstanding, and so they wanted to reverse the onus, so you have to come in and prove this, otherwise we'll cut your benefits off. And there was outrage about it. I actually had one myself involving the CSA, Child Services Agency, where it took the mother of my child's income and my income from last year, and so there's this number, and there's this number, and hers is much bigger than mine. And the amount that I was supposed to pay, based on the number of days of care, which didn't change, was 0. And below that, it's got the next year's one. And my income had gone down, and hers has gone up. What had happened to this number? Was it 0? No, it moved from 0 to a number. And I looked at that and think, that probably can't be right. It's a classic example of just using an information system and spitting out a result. And the reason why it was problematic, I actually had an audit from the AAT in relation to it as well. And so that example of going through and looking at data, you have to know what you're doing. You have to be looking at the data and actually be understanding what that is. And look, here, by the way, I'm actually talking, the rule for irrationality is talking about statistical data that's gathered. It's not talking about calculations inside statutes, because that sort of stuff is actually going to be an error of law if they've just misread statutory phrases anyway, stat sections. Okay, and I'll do this slightly out of order. I don't know why I've got these out of order. I'll try and do this properly. This is going to be interesting. This is a case of Simon not updating the slides from last year, because one thing's changed. One important thing has changed in the law in the state of Queensland for this year. What came into effect this year in Queensland? When I say big piece of legislation, the human rights legislation came in. And so Queensland ostensibly is now a charter jurisdiction. But I'll get to that. Start with proportionality. Now, when we talk about proportionality in constitutional law, usually that's in relation to things like discrimination in Section 92 and the taxation. Turns out, if you charge a fee for stuff as a government department, that fee can't be revenue raising. At least it can't in the federal government. So that when they talk about the fees that are payable, and particularly again in constitutional law, they talked about this in relation to the tobacco excises. There's a really important distinction between regulating and taxing. And why is that important for the federal government? Because of the way their heads of powers work, and the way that taxing statutes have to be passed through the lower house, only about tax, only about one issue of tax. These things have to be done in a certain way. And so the courts, again, this is constitutional law principles, will look at how proportional this amount of regulation, and particularly the amount of dollars you're charging people, is in relation to the issue or area that you're actually trying to regulate. And here, what was that? It was one of the migration cases. They talked about this distinction in terms of delegated legislation. You can go and have delegated legislation, and in instruments that you are giving somebody the power to go and create. Go and have the little Townsville City Council. It has the power to go through and create parking fines. It's got the Transport and Other Road Users Management Act. It says you can go through and stat body, Townsville City Council, you can go through and charge people parking fines. And those parking fines can't be more than 100 penalty units, like $10,000. All right? And when that instrument is created, what do we pay for parking fines in the city these days? Anybody have one recently? How much is it? Really? Well, the way it's structured, you actually get a 50% discount. When they give you the tickets, I think it is actually literally it's $35. The fine is actually $70. But they say if you pay within 28 days, we give you 50% off. If you challenge it, you've got to pay the full 70. And if you challenge it and lose, because, well, I won't mention names of magistrates, but you challenge it and lose, they also charge you a very large amount of fees. But nonetheless, what if the Townsville City Council had, instead of making that $70, had made it $7,000? Strictly speaking, they're not exceeding their power under the legislation. It does say your parking can be up to 100 penalty units, right? Which is, as I said, about $13,000. In theory, they could do that. They have the power to create delegated legislation. This is one area where looking at the inherent unreasonableness of delegated legislation, you can take into account lack of proportionality with such things. But by default, when Parliament sits and does stuff, Parliament can do whatever it likes. It can go craft things out. And look, Parliament can also say decision makers must use a test of proportionality. They must allocate things in accordance to these other set of circumstances. So, for example, the Passports Act might say something like the decision maker must place a great deal of weight on the likelihood that a person is going to commit terrorist attacks internally or externally as a result, perhaps, over those things. Parliament can go through and do that. When decision makers are going through and doing it, by default, it's not usually something we take into account. So a decision maker can't say, we thought that this particular thing was important, and therefore we've placed greater weight on that. That's not how this works. Parliament determines that. You as the decision maker do not. I said, with this one area of exception, which is looking at delegated legislation, which actually has to be reasonably adapted to the circumstances in that situation. So your $7,000 parking tickets, probably not going to fly. Can actually get up in terms of being inherently unreasonable. And it kind of makes sense. If you've got a $7,000 parking ticket, it is strictly speaking what the council can do. They do have power under the Act to do that. This is an area where the courts will look at and say, not really proportional, this delegated legislation. Broad prohibitions. I don't know if we've got the Gold Coast case. I mentioned a few weeks ago that regulation and prohibition are two completely different things. If you're given the power, delegated power, to regulate, that does not mean you can stop something. It just does not. I said the Gold Coast City Council, it's a narrow ultra vires thing. It's outside the scope of that particular power. And having this ability to discriminate against people in delegated legislation can be problematic. Because when we're going through and looking at this, the amount of weight that needs to be placed, again, thinking about the Passport Act, we will place a great deal of weight on men applying for passports, that have child sex offences. We will place a greater deal of weight on that when doing this application. No, you can't go through and do that. That falls under this lack of reasonableness in terms of the under the Wensbury principle. Now, again, I think you do I can't pronounce it. It's the Charter case, the Victorian Charter case, drug dealer, Malevolent. The case that's written on the bottom, starting with M. Now that we're, I guess, a charter jurisdiction, maybe this thing's going to happen again. Happen in Queensland. the way that our legislation is crafted, it's very similar to the way the Victorian and the ACT ones are crafted, essentially gives a person the option of piggybacking. So if you bring an action in any other area, again, I'm thinking here in terms of administrative review, you can also bring an action at the same time for a breach of human rights as part of that. So it's this idea of a piggybacking cause of action. So you fill in your form, statement of claim, I wish to seek judicial review. Statement of claim? Application. It's an application of the court. You fill in your application. And I also want to have a human rights action as well. And the key thing to note, and I remember raising this when this came up in the context of administrative law, it's that you couldn't get a human rights action on its own, can't get you a dollar value. Well, that's nice. And I just remember asking them and not getting very good answers, so I haven't checked the legislation. Feel free, for those that are interested in this, go there and have a look. Because I said, does that mean you can get administrative law writs, though, under human rights breaches? Because that would be really interesting. If you can't succeed under the JRA, but you could succeed under the Human Rights Act and get a judicial, one of the writs, a writ of certiorari or mandamus or prohibition, that would be both funny and terrifying. I asked them this when I went to whatever the local government department that cares about human rights is. I can't remember, the Human Rights Commission or something. And I got, no real answer. They had no idea what I was talking about. So, don't know whether or not that's in the Act or not. I suspect, given that it's carefully modelled on the Victorian one, I suspect that people have already mapped this out and excluded it. And I actually think the way that explained it to us was just wrong. They didn't know how the thing was structured. That's fine. So it might be worth going and looking. And just make note that in the interpretations of the Charter, and the Victorian one's been around for about 30 odd years, that they do have this test of proportionality when they're looking at the amount of weight of various decisions that things are taken into account when determining whether it's a breach of human rights or not. So again, whether or not this is going to inform the act of judicial review, I don't know, but it can possibly the interpretation of statutes. It might go and change that. I said I put this in the slides last year. I haven't looked at it since in terms of whether or not that's going to impact or change the way administrative law is going to work here. Watch this space. Okay. So that third category is to do with discrimination, and that idea of having, as part of the administrative decision-making process, having and doing things that in substance discriminates against you. So again, thinking of examples, possibly granting a passport, what's it going on? Possibly driver's licenses, maybe foreign driver's licenses. Doing a grant in relation to that, or administrative decision makers determining how and where things sit in terms of discriminating. Now, if hypothetically, and I know this has changed this recently, but if hypothetically you were a woman and you were from a jurisdiction where you're not allowed to drive, the person's from Saudi, for example, is coming to Australia and applying for a driver's license. This is where things get a little bit tricky. Whether or not you can actually discriminate, whether it's the administrative decision maker is actually doing something which is inherently unreasonable or not. I did mention that these things can be tricky because the courts don't want to be stepping on the roles of the merits review. They don't want to be delving too much into the underlying factual stuff. And so they will always say, in regards to unreasonableness, is this logical? It's not whether or not it's good or bad or whether it's fair or right or just. Is this logical? And so look, you can actually do these sorts of discriminating steps, and and that will be fine. You can go through and discriminate. Again, if we don't want to have discrimination, Parliament can do that. Parliament can say you can't discriminate in these decisions on the basis of sex, for example. And they do. There's a whole bunch of statutes that say in certain situations you can't discriminate the basis of religion from employment issues. You can't discriminate in regards to sex or race, or there's a variety of things, of disabilities, I think, these days as well. Parliament says so in a variety of circumstances, and if they don't, well, decision makers can do this. They can actually go through and make claims. You need to be higher than 5 foot tall to be a fire person. Or, perhaps that's not a good example. Fighter pilots? I think the military is allowed to discriminate. If you're blind and you're a fighter pilot, I don't really know. But again, usually it's the role of Parliament to map these things out. But by default, if administrative decision makers are actually using discriminative criteria, it's not an error of law, provided the thing is logical. It actually has to have an internal logic, and that has to be able to be shown. In Lee's case, and it would have to be Robert French. It would just have to be. 2 more slides, I'll take a break. Wall of text, Chief Justice French, as it then was. And this is Lee's case, which is, I think is only a case list. And he uses the phrase imputed on the legislature. We presume Parliament is not dumb. We assume that Parliament will go through and map out things in terms of what is going to be considered reasonable and not reasonable. And appreciate if they say these things must be taken into account, or these are the limits of the power. There are other parts in the JRA and the ADJR we can use. We don't actually want people to be jumping into this area often. We don't want to make it easy, because it's really the courts delving into the merits review area. And so as a result, he just writes so many words. So that, they're actually talking about reasoning, and that we as people, judges, can disagree all the time in our system anyway. We as reasonable people can take a whole bunch of the same bits of evidence and come to different results. It's not an error of logic to do that. It just happens. Something has to be, really grossly wrong and inherently structured in such a way for us to determine that there's an error of logic, so that something's unreasonable, irrational. And another way of explaining this in a much cleaner way, with fewer words. Is Hain, Kiefel, and Bell. A conclusion which may be applied to a decision which lacks an evident or intelligible justification. Slightly different language. Fewer words, though. Always happier with that. It's really about not seeing the logic. We accept that people, great minds think alike. Well, no, they don't. When they're weighing things up and coming to a particular result, things have to be out of whack in regards to weighing things up and achieving a particular result. And the last one is more just a general purpose of intent in relation to that. That we always, with this aspect of administrative decision making, there is a statutory framework, and we have to see how the logical steps have happened in regards to little bits of evidence, but they're still within the umbrella of the statute itself. The context that this thing is read in, and whether things are rational and logical, still have to go back to the statute itself in terms of aims and purposes. Things should always be interpreted in that context. They're not read independently as this abstract series and steps of logic. I think we might take a break there. So it's a little bit dry. I'll hit the pause when people have finished typing it up. Does anybody have any questions on this stuff? It's a little bit rough. It's a bit rough to get this through. to really get this through. It's helpful in a lot of these situations. Let's have a look. Okay. So, earlier I mentioned that in the rules of evidence, things have to be relevant. Right? Something's not relevant, you can't admit it as evidence to prove a particular point. But there is an aspect when looking at a particular piece of evidence, it might be relevant, but it might not actually have any probative value. It might be related to the thing you're doing, but really not be able to prove a particular point of law or fact. And when you've got a bunch of things that might be relevant and the decision maker's gone, put weight on it, but the courts can't find, again, we're thinking here in terms of judicial review, that evidence collectively with all of that weight could have led to the particular administrative decision, that is going to be an error of law. It's basically the justification that somebody has that's based on really small things. So, for example, going back to the passbook example, a person may take into account, say, terrorism-related activities. And you guys, most of you probably won't remember actually, there's a gentleman, I can't remember his name, Muhammad Hasif, might have been his name. He was a doctor anyway. And he had lent or given a SIM card to his cousin. And just by a strict interpretation of that statute, that was, and the cousin by all means had gone off overseas and done some terrorist-related activities. So strictly speaking, that was providing something to another party to do terrorist things. And so when we're looking at the amount of evidence that's required to reach a particular conclusion, this doctor in this case was a materially aiding terrorist, and as a result he should have his visa cancelled or his passport refused. That claim that's made, the thing that had to be pointed, that this person was materially supporting terrorism, only had a tiny bit of evidence, just this tiniest of thing, one SIM card in relation to that. So this aspect is to do with quantity. If there is evidence, and look, don't get me wrong, strictly speaking, that was relevant, so it's not going to fall under the other area. And we're not looking at the relative weight here that the decision makers put on it in terms of the quality. What we're saying is that even if this is completely true, in order to prove this particular point, decline the guy a passport or a visa or whatever the thing is, it's pathetically small as something that's proved in order to reach a particular outcome. There's just not enough points. Again, when a decision maker and a government decision maker makes a decision, they give their statement of reasons. If there are very few of them, and they're for very minor things, this is the area where you can jump on them and say, look, yeah, you've made a decision. All of these points are relevant, but they're very, very minor. They don't point or tend to prove the particular point very much. In evidence law, you guys learn about circumstantial evidence and how a person can never be found guilty of a crime beyond reasonable doubt unless the circumstantial evidence collectively, you can be found guilty beyond reasonable doubt by circumstantial evidence, where each individual thing tends towards proving. It doesn't actually directly prove a particular point. You can be found guilty beyond reasonable doubt for circumstantial evidence if there is no reasonable alternative scenario that could have happened other than the person being found guilty. And here, if we think about the same thing, idea of things that are a little bit probative, a bit like circumstantial evidence, a little bit probative if it doesn't have this critical mass pieces of information, and the decision maker is essentially flying blind. That's what they're trying to get at here. The courts can go and give a remedy as a result. That particular last point, I remember reaching this point last year when I was teaching this too, and this thing comes in, there's two limbs to this particular component of this. So we've got the first one, the court, this ground, so in other words, the lack of evidence ground can't be satisfied unless the decision maker is required to draw upon material to reach a decision and there's no evidence of this particular fact. So in other words, the statute says they have to find some evidence to prove a particular point, and there just isn't. There isn't, that doesn't exist. Or they've gone to rely on a particular fact or a particular feature, they're trying to prove a particular point, and they can't. There's a particular fact or point that's supposed to exist, and it does not. And so an example there would be, going back to my terrorist case, relying on a particular point with, instead of the SIM card, if instead there was money that was transferred. You could transfer money, but no, SIM card's probably a good example. Giving a SIM card, but instead of giving the SIM card, the person left the SIM card somewhere. The other guy just came along, just picked it up. I like that. And so that we're doing these things. Yeah, I suppose strictly speaking, you could make an argument that it was there was a connection between these two things, but fundamentally, and as a fact that's going to prove a particular point, it's just going to fail. There's just not enough substance behind a particular finding of fact to lead to a particular result. There's not enough substance, not enough meat. All right. Okay. And I repeat this phrase here, that findings of facts must be logically probative. Finding of facts have to tend towards proving things. This this aspect of judicial review is connected to the equivalent rules of evidence. Now, as we are aware, administrative decision makers are not strictly bound by the rules of evidence. They're not. Neither are tribunals. Make this point that when seeking merits review, again, in a couple of weeks' time, we'll talk about that. And for anybody that's ever had to go to QCAT at all, either for an administrative decision-making decision or any other, residential tenancy, consumer and trader dispute, when you rock up to QCAT, they are not bound by the rules of evidence. As I discovered last time I went there, because it turns out the parole evidence rule of contract law, excluding things that aren't enshrined in a contract, is strictly speaking a rule of evidence. I was really angry with them. But when decision makers are doing that, even though they're not bound by the rules of evidence, their decisions have to flow from things that tend to prove facts in order to reach a particular result. Statement of reasons has to flow from bits of information that tends to prove stuff. Tends to prove facts that need to be proved as a result. Okay. Next area is uncertainty. This isn't actually very big because it doesn't happen very often. King G is the case for that. And in King G there was a formula. This is where you've got formulas that some bureaucrat has worked out and no one else can work out how it operates. And so there, I think it was a wartime thing as well. Yeah, it was during the war. Second World War, trying to work out a formula in terms of allocating the clothing or cloth or something similar. The amount that had to be allocated was a series of formulas, and no one could work it out. The bureaucrats couldn't work it out. The courts couldn't work it out. And they said, look, this is one of those times where if a power that's been given to a decision maker is so uncertain and incapable of being discerned by the decision maker, by the person who's the decisions that are about to, and the courts themselves, that's just going to be, trying to rely on that formula or trying to make decisions under that are just going to be too uncertain. This is really an exercise in stat interpretation. When you're going and looking at a power and trying to make a decision under it, in situations where you can come up with a variety of results depending on which specialist, which expert witness you've got to analyze those particular things. And again, where the formulas themselves don't make sense. I'm a software developer, you say, by trade. I spent 10 years cutting code, we call it, and it was not common, but not, did happen from time to time, when you were dealing with people, usually management, who want things done in a certain way. And when you're going and you're analyzing those things, taking their decisions that they've made and enshrining them into code, you actually realize when you're putting it in code, what they've asked for does not make logical sense. Sometimes you tell them on the spot and they still tell you to go and do it, and then you trot back with the result. What do you mean you've made more sales and not enough things this month? There was one in real estate where you had leads, so a number of people that would come in, you'd go and have leads, and then you'd have the number of sales. How could you have more sales than you have leads? Well, because they're from previous months. We told you this. Doesn't make sense. You do one here and over there. Oh, yeah. Going back and having to do stuff again. And so that when looking at some of these formulas in statutory frameworks, when decision makers are using them, some bureaucrats aren't the brightest of sparks. And sometimes things have been written into instruments that are very hard to read and sometimes are internally inconsistent. So where instruments are internally inconsistent, trying or purporting to make decisions under those instruments are going to be outside the scope. And so you can seek remedy under judicial review for that. Interesting to see what your remedy is going to be. And sometimes it's just the declaration, where the courts say, oh, yeah, no one knows how this works. We're going to declare it to be this, even though we know that that's probably wrong. Okay. And again, the courts said, question of scope and degree. Some things are just complex and can be worked out, and other things are internally contradictory. So that latter type, where people are purporting to make decisions, they're going to be outside the scope of this. Things being complex, it's not going to be uncertain within the meanings of judicial review. All right. Discretion. It's important to note when you give power to people to do things, make decisions about the rights and status of others, those particular people that you're giving the power to, unless the instrument says so, can't give the power to someone else to do. It's a really important thing to note. When we give power to people, they can't wash their hands of it. They can't do things at the behest of others, which is a separate part. And they can't deny the existence of their own power. And this comes up in regards to policy. This is my particular beef with some academic institution that may be close to all of us. The understanding of what policy is, in my experience in this institution, is pathetic. Yeah, I've said it on YouTube. And the reason for that is that people equate policies with being blind, rules that they are blindly to obey. And in fact, the reverse is true. It is an error of law to blindly obey policy. It's a really, really important point, because it is not uncommon for government departments to issue policy. One that came up for me in practice was the 3 strikes rule for residential tenancy involving public housing. So the government department, the Department of Housing, what it is in Queensland, might be Department of Communities, or I don't know what it's called these days. They had a rule that said 3 strikes, you're out. If you've had 3 breaches under the RTRA, the Residential Tenancy and Room Accommodation Act, in public housing, you don't get public housing from that point onwards when you apply. What's the problem with that? Well, that's a policy. That's a government department policy. And what we found is that people would come back and say, well, yeah, you've had 3 strikes, therefore you're not getting it. I'm like, no, that's not how this works. And bureaucrats don't know that. In fact, I'm not going to, but if I did a sample of people in this room, I would be surprised if every person in this room knew that particular fact. There are a lot of people who earn a lot more money than I do in this institution that do not know what a policy is. Policy is essentially a pre-made series of steps or a pre-made decision. So if this bunch of facts comes up, these are the guidelines we're going to use in order to resolve this. This is how, if these things come up, this is how we ought to go through and do it. But every time somebody comes up and asks for something, it's a decision. They have to make a decision. A decision maker must make a decision. The fact that there's a policy that will guide that, sure. Hey, we've dealt with 1,000 student complaints. And so as a result, we've developed this policy so that when a student complaint comes in, we've worked out that this is the most appropriate way to deal with that. And if there is this policy and a student complaint comes in, you can't just say, this is the policy. That's fundamentally not what this is about. It is fundamentally an issue or an error of law to blindly follow policy instruments. And that is different and distinct from rules. If there is validly passed legislation from Parliament or delegated legislation that says when a student complaint comes in, the person must do this, this, and this, that's completely different. They're completely different things. And I'm stunned. I have been stunned when dealing with government departments and bureaucracies at the ignorance in relation to this point. So, we're all starting to be lawyers. Remember how I mentioned the point at the start of the semester, how ideally, if I do my job properly, I'm going to turn you guys into people that bureaucrats hate, because you're going to become more powerful because you're going to know the limits to other people's power. And often, first of all, they don't like you challenging their power. Secondly, they often don't know the limits to their own power themselves. They know what they can do, what they can't do. You'd be amazed at how much this comes up. Okay, so just make note, this is the area where this happens. And just putting your hands up and saying, policy says this, that's fundamentally not how decision-making works. And person that does that, particularly if they're committed to writing, you keep a copy of that and you go and seek a particular remedy. Now, annoyingly, in a lot of these places, it often goes to an internal disputes resolution thing too. So don't think, armed with this newfound power of administrative decision-making knowledge, that you're going to be able to twist the university's arm. You probably can, but note that the internal systems have to be dealt with first before you can go to court. Okay. And this idea of you can't abdicate your responsibility. If you're a decision maker and you're given power under the Act, you've got to actually do that. You can't get another person to do it for you. And this happens. It happens a lot, where people say, oh, well, this person over here is going to make the decision instead of us. Particularly where they get third parties. outsourcing things to be done, outsourcing a statutory function of a government department to private people, private individuals and contractors. So just make note, that second point there talks about policy. We're talking about slightly differently. That's government-driven policy. So in other words, the Labor Party will try and uphold freedoms of workers, or what have you. And that those instruments that also flow down through government departments, guidelines, policy instruments. And again, James Cook University has a bunch of policies. The student policy, in regards to grounds for review. Decision makers always have to take things into account. And if they come back and tell you, oh, this is against the policy, therefore, you're already winning. Well, you're not, because your hours of your life are going to disappear because you have to deal with bureaucrats. But just make note that this system, you're on the side, you're walking into the light, away from the darkness. Okay. Now, that does not mean that they can't use policies. Clearly, they're allowed to use policies. All right, clearly, the whole reason we have these things is that we've had 1,000 student complaints, and we've developed a mechanism to go through and deal with the vast bulk of them. Each individual one we have to still consider. We can go and look at this policy and determine how it fits in regards to this, and then we are going to make a decision. And that's the key thing from NEAT trading, which is that the decision maker from time to time will need to depart from the policy. That is the fundamental nature of discretionary powers. If you aren't ever departing from the policy, you're probably not using your discretion. 1,000 students come in and you blindly follow the policy instrument in regards to all of them, you're probably not doing it right. So that's something, and again, I think the tutes we talk about this a bit more, but it is something I really want you guys to leave in the back of your minds in terms of how you're dealing, particularly with this institution. You guys, for example, you want a review of the subject, there'll be a policy for it. If you want to complain about the guy who waves his arms at the front of the room, there's a policy for that. But whenever you do that, discretion has to be made in regards to that. They cannot just say, I'm following this policy. The policy says this, this, and this. It certainly can guide their decision-making process. And because most of them don't know administrative law, from this point forward, you can be thinking about the result that you want, the strategy you can go about getting that particular result. I always said when teaching this, my friend Mel was the other tutor, and she was this lovely, wonderful, bubbly. In fact, some of you guys might have even had her in first year from LA 102. We're going to Melbourne this weekend. It's going to be great. She was always the good one, and I was always the bad one, because I'm looking at the cynical, nasty, very much real politic aspects of law. This is one where you guys are now armed with a piece of information, an important piece of information, and when you deal with bureaucrats from this point forward, it's going to be on the back of your mind, I swear. This is now in your heads, and it's a transformation you guys go from law student to lawyer, knowing how and where these things exist, because most people don't know this. You can seek remedies through the courts where people are blindly following policy instruments, because it's an error of law if they do. All right, last slide. This one's hard to prove. Bad faith. Look, basically you can prove this if you've got written evidence that a person's doing something for an ulterior motive or another purpose. Very, very hard to prove on the facts. Because in life, people don't like other people. And we have other mechanisms where there's bias. other mechanisms in terms of seeking some sort of result or remedy. Here, it's really about the intent. If a statute is set up to do things in a particular way and you're using it or misusing it, that particular discretionary power, for an ulterior motive or to achieve an alternate purpose, that's bad faith. All right, when you're going through and doing things, and again, it is tricky to go through and prove. Yeah, in fact, there's that last point there with collective decisions, things that have been made by multiple decision makers. Proving that a group of people have an ulterior motive to use their discretionary powers in a certain way that's a very high bar. They're all wanting to use the discretionary powers given to them in order to achieve purposes that don't relate to those discretionary powers. And look, people come up, I go into community legal, and people come up and they reckon that council are out to get them. Council have always been out to get them. It's like, well, all of the council? Maybe just that one person who you pissed off a while back. Maybe you do have a point. But collectively, the Townsville City Council is not out to get you. And even if they are, you're going to have an incredibly high bar to achieve some sort of remedy, to actually be able to prove that in court. So bad faith is tricky to go through and prove. And strange, I didn't think this was going to go for 2 full hours. But the break went a little bit too long, but I don't have anything else to add after this part. But we've got a tune now, so we're going to trot along to that, talk about the test. Okay, team. Much appreciated. I'll hit this up.